I GC News, Bema Obibia Aquaba. I had the latest and hot news in Kwana Midi, Bramo. Nuti, so we now subscribe ya, or more than say over subscribe to the channel. The way I say over click the subscribe button. Now, what barely notification. When sir, you be a happen when the first person out, sir, they can a video. I think we are now, what like video. My thumbs up, give us a thumbs up. Now, feel. Share my Ato Forson now when you be here na wo hu ensema ekoso ewo Ghana memo hano afi yebura ye ensema ababeto yepono so yiti eye sansemi ya ekoso report ya ababeto de yiti yeposo yiti
Afenyo Markins call no okoka Supreme Court say MPs miensa mo MPs MP ena ema Alban bag bin gina so ebu asem no enso ukọ parliamenta na eye MPs 9 omo ho asem and ma Alban Bagbin a take decision or take into what will make the Supreme Court take half truth and try to judge or make a ruling on half truth, because you cannot go to court with half truth. And it's when you go to a parliament, you will see this. I'm trying to get you everything. Mama Yankonko the Chief Justice and the Supreme Court timer. Speaker of Parliament, the lawyer Kasaye.
And so that was taken into account before the court that makes the excessive orders relating to even 4 parliamentarians when the writ itself affected 3 parliamentarians. It didn't even include Article 97, 1 each. And so all of those orders were made based on some of those findings. And I'm saying that, and the position is that the first defendant, based on these things, expects that in order not, especially when the court reaches the conclusion that on the balance, there was no balance, there was just one side of it, because it was an ex parte application. And they were ahead. What was the balancing? Sorry. Yes. I thought you were just responding to a very straightforward. Oh, yes.
But now, the case that we are hearing into the substance of the motion itself, I would urge you, rather, to restrict yourself to the objection that and answer it, whether it's scandalous or it's not scandalous.
This is not scandalous.
My problem is, yes, if your learned friend on the other side has raised these matters and you think it's not scandalous, you don't have to, as it were now, veer into the substance of the application itself.
My Lord, I needed to demonstrate that these things were not just said out of aim.
Just restrict yourself.
My Lord, I thought I was doing that. And so, as far as I'm concerned, apart from the use of the word scandalous, which he just used, he doesn't demonstrate how scandalous it is based on the context of the application that I have before.
You allege that the Chief Justice is privy breach of a constitutional provision. What are you trying to convey?
It may have been by reason of inadvertence. But if that's a statement of facts,
was it necessary for you to add that in your depositions? For you, what exactly were you trying to achieve? By adding the point that the Chief Justice was privy to a constitutional breach. I think that is the point it was.
Oh yes, but the point is that if she was privy to it, her ruling must reflect that. If it doesn't, it's one of the grounds upon which I'm urging the court to set it aside.
So, Speaker of Parliament lawyer, the otchere Supreme Court say Afenyo Markins baha abeka say MPs miensa ho asem na Alban Bagbin gina so ebua na asem e was speak Parliament. Nanso anya no kre. Nipa ye ka omo asem omo ye 9. Inti ede na Afenyo Markins eba Parliament eba Supreme Court ebedi atro mo say nipa miensa en ho asem na Alban Bagbin egina so ebua say NDC majority. And judge for me to say, oh, now asana wakano, pese ebusa say, den na waka say Chief Justice Krampo no, the oye no entwa ye. Omontia say, obi beka say Chief Justice take decision bia, sad decision no, scandalous entwa ye. Into omo problem no say the word scandalous. Omo problem no say, den na waka say Chief Justice decision bi o take ye no, based on the Afenyo Markins by na entwa ye. Inti de enti na emane kasa. So Chief Justice akasa na entwa ye. So how can we be here that we are dealing with half truth? Because after Afenyo Markins in Parliament, time Alban Bagbin eka say MPs and 9 abaku free NDC, miensa free MPP, where you are mato kunyano. Adia chi no Parliament krano, they were supposed to do what? They were supposed to, in fact, draft into Alban Bagbin ruling no. Now I was a Parliament at the court in Kratam into Ridia. So oko Parliament a year documentation mua. There was a memo. Alban Bagbin from Parliament no release after Afenyo Markins court no 21st of October 2024. Editor of Database Chamber Reporting, Office of Chamber Reporting memo. Say pursuant to Regulation 551C and 0 of the Parliamentary Service or Staff Regulation 2019 CI 118, explain why a disciplinary action should not be instituted against you for photocopying the drafts Hansard of Thursday, 17th October 2024, and making same available to some other persons without authorization. Your response should be submitted to the editor of Database Chamber Reporting by 4 p.m. on Wednesday, 23rd October 2024. Inti the CNSA, after Alban Bagbin making sa declaration of Parliament, what happened? And they say, sa a declaration, at the end of the day, everything that happens in Parliament, it was said, Yachrowie na yehu se mistake bi animu a na eden speaker sign and sign a official document. Now the moment ye be bibi of Parliament yen sign ya speaker engine tumu entimu so no, it is a draft enye document sebio obi abetime gina so take a decision. Into that ruling from speaker no, that ruling was not a complete statement, and I say a confirmed ruling from speaker. If you say now the ruling now make it was supposed to be entered into the document in Parliament to make it an official ruling. Now what happened? And they say adiebechino and more Parliament won't be a printed the ruling that has not been officially endorsed to be an official ruling. And Afenyo Markins on Franco court. Inti I must speak any break ka say document now de ma Afenyo Markins coin a draft document. Then autumn draft document at the mo be so on court. If you say every time they sit in Parliament, what they do is they go through all the things they did the previous day and see say if there was a mistake somewhere, they correct it. After they do the correction, then it is endorsed to say the previous meeting has been endorsed to be an official or valid document. Afenyo Markins took a draft document that has not been endorsed by Parliament. Into the document Afenyo Markins took to the Supreme Court, not sad document, and yet they're in the final document of Parliament. Into sorry, or your Speaker of Parliament, the lawyer and the Supreme Court to say, you have judged on a half case or on a half truth. What Afenyo Markins brought was not even an endorsed document from Parliament. It was a draft. And even after that, Afenyo Markins came here to say things that were not accurate because Speaker of Parliament ruled on 4 MPs. He did not rule on 3 MPs. So it is scandalous for the Supreme Court of the land to say it's a draft document and that it wasn't a document that has been adopted and endorsed. In the first place, the beginning of this whole thing was scandalous. The Supreme Court, which has the oversight responsibility to make sure, say, every document that comes before Osonmame and her battalions, those documents have gone through the litmus test. We will know. Because you see, the draft that Afenyo Markins took to the Supreme Court, if Afenyo Markins had sent the draft to the High Court would have referred Afenyo Markins or would have sent Afenyo Markins back to Parliament to present the endorsed proceedings. But because the Chief Justice was in a rush, the Chief Justice wanted to go against the process. The Chief Justice does not respect due process. She basically wrote Afenyo Markins' application for him, gave it to him and said, bring it to me and that I will make sure you get a ruling. That is why we are here today. So the Chief Justice is writing his own application and answering his own application and giving ruling on his own application. As we sit here, the Chief Justice of Ghana today is undermining courts in Ghana from her own hypothetical statement. How can you sit in the Supreme Court and make hypothetical statement that if the case had gone to the High Court, it would have come to you? You don't know. You never know. Because maybe if the case had gone to the High Court, it wouldn't have been an ex parte case.
Of case. Even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation.
But which one of you, sir, and your friend, your first segment way, Papa Anyashia, Bonia, your friend Bonnie, and also Enyashi. So I have 8 questions. In fact, let me see 1, 2, 3, 4, 5, 6, 7. 8 questions for a year. One of the women judges at the Supreme Court. Now, let me put this on the screen first. These are all the women are almost Supreme Court, so I'm going to keep this on the screen. Senebeya, when I put the questions out, all the women at the Supreme Court, no, obia dinwum into obia NTA. Why are they we concerned? No? Be honest with yourself. Come out and let the people know. Resign before it gets murkier. I'm not threatening anybody. I'm just saying, it will be better for all of us to protect our integrity. Emma Omo Ghana Supreme Court now, Omo 5. Justice Getrude Torkornoo, she is the Chief Justice. Justice Mariama Owusu, she's a judge, senior judge at the Supreme Court. Justice Avril Lovelace Johnson, she's also a judge at the Supreme Court. Justice Professor Henrietta Joy Abenanyakum Mensa Bonsu, she's also at the Supreme Court. And Justice Barbara F. Aka Yensu, she is also at the Supreme Court. Team, stay with me. Now, Mr. P, stay with me. Mr. S, stay with me. My first question to these judges, there's one judge I'm sending these questions to, and we are going to cut this piece. The judge now, Owasa Emma Wimuno, also Obabon Tebe Ansa. There are videos, there are car numbers, there are pictures, there are text messages. Nobody is God in Ghana. Say Papa a friend Papa Anyashia, Bonnie a friend Bonnie Enyashi. Now, which Supreme Court judge or your bar, which one of you goes to sleep at McCarthy Hill? Which one of you Supreme Court judges you say you are married goes to sleep at McCarthy Hill? Second question. Which of you Supreme Court judges or your bar, the place you go to sleep, the gentleman now, that gentleman was going through a divorce, and you, the judge, are one of the female Supreme Court judges. You actually got that gentleman a lawyer. Question number 3. You, the Supreme Court judge, your bar, sa nipa 5 you are about 15 years older than this gentleman. You are about 15 years old. You are older. You are 15 years older than this gentleman. That's question number 3. Question 4, and this is a specific question. There is a place near the Swiss school, near Akufo Addo's place. You, this woman, have you been sharing bed in that neighborhood with a member of parliament? Listen, there is a specific place near the Swiss school. It's very near to Akufo Addo's place. You, the Supreme Court judge, you are a woman. You say you are married. You have been sharing bed with another politician. I'm giving you specifics so that you know that I know what I'm talking about. Who is this gentleman? Question number 5. Now, let me go more deeper. The gentleman you, this chief person you are seeing, the person you, this judge, you are seeing in Ghana is a businessman. He's rich. He's less educated. You, this woman judge, you go to this man's house. And the funny thing is you leave the house 5 a.m. every morning. 5 a.m. The gentleman's name is Emmanuel. For some reason, I'm not going to add the second one. He is linked to some kind of milk in Ghana. The gentleman is called Emmanuel. He is linked to some kind of product in Ghana, milk product in Ghana. His name is Emmanuel. His date of birth is the 31st of March. I'm being specific so that you know what I'm talking about. There are pictures, there are videos, there are chats. Because most of you are saying you are Christians. You are married, you stay with your husbands, there's no problem. The gentleman is called Emmanuel. He's linked with a product called milk. This gentleman was born on the 31st of March. He was born on the 31st of March. Okay. You always leave this place at 5 a.m. You change cars. So we have about 3 car numbers and the 3 cars that you use in going and coming every time. Now, this is specific. What was Afenyo Markins doing at you, the judge's place near Wireless around Cantonment? What was Afenyo Markins doing at your place? What was Afenyo Markins doing at Wireless around Cantonment? What was Afenyo Markins doing at your place? On the 11th of November, Papa Anyashia, Bonnie Anyashia. In court, another issue says here. Chief Justice Owusu where to be in there. The Chief Justice making a ruling, no, or in her submissions or ruling, no, or say if Afenyo Markins had gone to the High Court, the High Court would have still come to them for interpretation. Alban Bagbin lawyers raise the issue, no. Omo can be say, in fact, so we read the constitution, now we follow constitution, now person udi no kra. Nanka or say Afenyo Markins echo edien a High Court. But Afenyo Markins ended up at the Supreme Court. And the application from the speaker, lawyers say, it is not right for Afenyo Markins to even, at the end of the day, come straight to the Supreme Court. Even though the Supreme Court oversees or is powerful than the High Court, we should all follow due process. As far as the Constitution is saying, there is the room, we still have an option to use, Afenyo Markins was supposed to use that option. Because in Ghana, Supreme Court, High Court. But the Constitution so says Supreme Court, High Court. But the Constitution also insisted, I was say issues like this, majority of them, has to come to the High Court. The Constitution recognizes the Supreme Court as being the the highest court of the land. But the Constitution also did not. The Constitution also did not discredit the High Court. It gave the High Court specific role to play in issues like this because Constitution will say due process is very important when it comes to law. In Toka say, even though the High Court, the Supreme Court is there, you have to go to the High Court first. So why did Afenyo Markins come to the Supreme Court? Chief Justice started using hypothetical statement in her ruling. Now, when a Chief Justice sits in the Supreme Court and start using hypotheticals, because the probability say Afenyo Markins echo High Court or Beba Supreme Court, you cannot say it is definite. No. The probability say case, it could have ended up in the High Court, it is also high. So how can a Chief Justice sit in the Supreme Court and say, if even Afenyo Markins had gone to the High Court, it could have still ended up on her table? It means the Chief Justice sits in the Supreme Court using hypothetical statements to judge a case that are supposed to go through due process and definite actions. Now, listen to this.
Third, it is the most basic tenet of our legal system that different courts operate in different jurisdictions, and every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court, the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte Senator Rawlings, citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution, and every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation of Article 97(1)(g), because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Article 99 reads, "The High Court shall have jurisdiction to hear and determine whether elected as a member of Parliament or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal." From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of Parliament or a seat of a member of Parliament has become vacant as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament that by filing nominations to contest as independent members of the 9th Parliament, members of the 8th Parliament should be deemed by reason of the meaning of Article 97(1)(g) to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g).
So you see what she tried doing here? She tried to override the power of the High Court because she wanted to take over the case. She knows that if Afenyo Markins had entered the High Court, the outcome that Afenyo Markins is getting at the Supreme Court, he wasn't going to get. Because when you look at the jurisdictions of these courts, the High Court has original jurisdiction and the Supreme Court has referral jurisdiction. Meaning, there's a reason why the High Court has original jurisdiction and the Supreme Court has a referral. That is why it was very imperative for the Supreme Court to send Afenyo Markins back to the High Court for him to exhaust the process there, and that when the process is being exhausted, it can come to the referral, which is the Supreme Court. But in this case, the Chief Justice sits in her chair and tells Ghanaians that forget the High Court. There is no importance to the High Court. It does not have any role. In fact, we as the Supreme Court, we can override whatever the High Court does. Then from the Chief Justice hypothetical statement, whatever goes to the High Court, the Chief Justice from the Supreme Court can just enter the High Court and say, bring it to the Supreme Court. Then it means the Constitution that created the High Court, at the end of the day, the same Chief Justice is undermining the powers of the High Court. So if you're a High Court judge today, Your Chief Justice sits in the Supreme Court and says that no matter what, a case can come there, and if she wants that case to come to the Supreme Court, she can quash the powers of the High Court and bring it to the Supreme Court. But there's a reason why the Constitution actually decided to bring a High Court, brings an appeal court before a Supreme Court. Because when due process is followed, then you get to know the real facts of a case. There's a reason why when the issue of parliamentarians and all that came up, it did not directly, or the Constitution did not directly say go to the Supreme Court. It said go to the High Court, because the case needs to be started originally so that we will know. Because you see, the draft that Afenyo Markins took to the Supreme Court, if Afenyo Markins had sent the draft to the High Court would have referred Afenyo Markins, or would have sent Afenyo Markins back to Parliament to present the endorsed proceedings. But because the Chief Justice was in a rush, the Chief Justice wanted to go against the process. The Chief Justice does not respect due process. She basically wrote Afenyo Markins' application for him, gave it to him and said, bring it to me, and that I will make sure you get a ruling. That is why we are here today. So the Chief Justice is writing his own application and answering his own application and giving ruling on his own application. As we sit here, the Chief Justice of Ghana today is undermining courts in Ghana from her own hypothetical statement. How can you sit in the Supreme Court and make hypothetical statement that if the case had gone to the High Court, it would have come to you? You don't know. You never know. Because maybe if the case had gone to the High Court, it wouldn't have been an ex parte case. So how do you know that when the case goes to the High Court, it has to come to you? The Chief Justice of Ghana, Madam Torkornoo Osnomame, today sits in Supreme Court and undermine the High Court and tells us that even though the Constitution gives the High Court the mandate to oversee these issues, she does not respect the High Court, all because she's there to work for Afenyo Markins and Akufo Addo. That is the problem of the day. That is our problem as a nation. And you see, this is what they are doing, and this is part of the reason why today, that is why today in Ghana, we are all saying our democracy has been hijacked. Now listen to this part.
To the Speaker, or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2, notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of Parliament. Now, clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. The plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. Even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of parliament and the speaker, it does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. Correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of parliament and the speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself.
So when you listen to the Chief Justice, right? And then Akufo, because the Chief Justice, the ruling was already prepared. Yes, it was already prepared. It was a ruling that she had already written. This was not a ruling where Omoko shared them 30 minutes or otchere. No. You know why? So a person who's a ruling was already prepared. It was when the lawyer for speaker raised the issue of the drafts. Because if the Supreme Court or the Chief Justice had not already prepared her speech, she should have known that the issue that happened in Parliament for Afenyo Markins to run to Supreme Court and the draft document he brought, she should have known that it involved 4 MPs. But because the day na Afenyo Markins ever court now on one catastrophe application man be presented to him, no, the Chief Justice had already written down her ruling. It is a the ruling now, which my team they are trying to get you. Her ruling was only based on the draft document. But you see, when Alban Bagbin was replying to the Supreme Court, Alban Bagbin made the Chief Justice understand and say it is scandalous because Afenyo Markins cry document so case it's a draft document that does not cover the original or endorsed the parliamentary documents.
You're waiting for Wayne reporter about the Tróuble so because just news so and our no so we can subscribe say we subscribe to the channel. Now so what like video to give us a thumbs up. Now share my Ato Forson when you be here now and someone also Asante Bediatuo latest and hot news on the bremo. Also get me otchere what Gyamfi and somewhere now comment box over to Gabby in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.